My watch says 5 o'clock. Good evening, everybody, and welcome to the Trafalgar Property Management webinar for September. We've got an incredibly interesting topic this evening for Jennifer and Corinne and myself to discuss. We'll be discussing the access to information in community schemes. You can only imagine the myriad amount of queries we get on a daily basis regarding POPI, PAIA, the Consolidated Practice Directives even. So we think it's an incredibly topical matter and a very important one and relevant one to discuss to this evening. We could just see from over the 400 responses that we received for the webinar, it's definitely going to be a goodie. So thank you very much once again for joining us. This evening, as I mentioned, Jennifer Paddock is going to take us through some slides. Jennifer, thank you so much for attending this evening. It's always lovely to have you on.
Thank you, Peter. It's a pleasure to be here.
And with me this evening, as always, is the wonderful Corinne Kutsia. Corinne's going to be handling our Q&A and taking us through a little bit of a demonstration in a couple of minutes as well. Just by way of a short biography, Jennifer Paddock is a specialist in community scheme law. She's dual qualified as both a South African attorney and an Australian solicitor, with nearly 20 years experience in the field and mentored by her father, Graham Paddock. Jennifer is the founder of Jennifer Paddock and Associates, a firm dedicated to providing a legal advisory and training services to the community scheme industry, and is a director of Paddocks as well. So before we get going onto Jennifer's slides, which I'm sure you're very interested in seeing, just going to do a short introduction, and then Jennifer's going to go through her slides. We're going to keep all of the questions for the end for a Q&A. So please keep those fingers typing. You can see in the top box, right up at the top, you've got a Q&A that you can go and press and go and answer all your questions there, or ask all your questions there. Corinne's going to keep us updated throughout the session as well. If something topical comes up, it's more than welcome to interrupt us. But we're going to keep most of those questions for the end. If we don't get to some of your questions, we will do so after the fact. Our contact details are going to come up in the last slide as well. And then we'll just do a short closing thereafter. The recording link, the slides, as well as Jennifer's checklists will also be provided to you after the fact. We'll be sending through a further email with all of that on. But also, you're more than welcome just to access the Trafalgar Property Management YouTube page. All of our previous webinars are there on as well. As I mentioned, the questions in the Q&A, and Corinne's going to be monitoring that for us as well. Hopefully, we get to everything. Sometimes we don't. We do get a lot of questions through these, but we'll try and answer as much as possible as well. As I mentioned, the contact details are going to be at the end, so you're more than welcome to use those. We're very open to taking questions after the fact. Specifically Jennifer from her side as well. A short survey is also going to pop up in the last 5 minutes. We really need your feedback. We'd love to hear from you what new webinars you'd like for us to do, feedback on the current session, what works, what doesn't work, perhaps the timing, etc. We are going to run this from 5 to 6 as usual. So please fill that short survey out for us as well. Then to introduce a new Trafalgar employee is Corinne Kutsia. She's going to be introducing TESS. Corinne, can I hand over to you?
Thanks, Peter. Let me just share my screen. Can you all see the Trafalgar website? Yes? Okay. So on our website, trafalgar.co.za, we have what you'll see here, property management. And if you go to training courses, you will see our new employee in the bottom right-hand corner. She's going to pop up just now. There she is. And she is called TESS. So in the bottom right-hand corner of your screen, you can see TESS. TESS stands for Trafalgar Inquiry Support System. TESS is our new chatbot. So basically, if you click on TESS, you will see that you can speak to TESS, you can ask questions, and the all-important thing is, I want to speak to a human. Then you can just click on that, or you can type, I want to speak to a human, and then you will see that there's either a contact form that you can complete, or my email address is there as well, which you can use, and you can contact me then via email, and I will answer your questions. Please note that TESS is still in a testing and a learning phase, and TESS is only directed to our training page. So you'll see on our training page, there's a number of things. There's our courses, there's the webinar recordings, there's guides, there's our resources that includes the question of the week and all of that. So TESS is currently only directed at our training website. We are busy exploring how we can further use and utilize TESS, but that's just an introduction to our new employee.
Thank you, Corinne. And she's done training basically on the Trafalgar website, or at least the training website. So all of those resources that's currently available on that training website is now available on TESS. So like ChatGPT, you can ask her questions, and she's going to take all of the repository, all of the information that's actually encapsulated within that training page, and share that as well. Fantastic. Jennifer, I know you guys are also very into AI, so this is an incredibly exciting development for us to do as well.
I was just thinking when we spoke prior to the webinar actually starting, and you said Corinne's going to introduce TESS, and I thought that was a human. And now to see that it's actually an AI chatbot, I'm so impressed. This is exactly what people want. And, you know, it can save so much time just because it's trained on your particular content, and it knows exactly how you feel about, you know, certain things. And I just think it's absolutely brilliant. So well done, Trafalgar. That is so amazing to see.
Well, because the Corinne is our resident expert, we almost called it Ask Corinne.
Yeah, I'm not surprised. Corinne 2.0.
Corinne 2.0. Jen, you can get going on your slides, please. Thank you so much. And just let me know if I need to skip.
No problem. Okay, well, thank you everyone for being here. I am really excited to share this information with you because this is a very topical and controversial topic that we're dealing with this evening, as Peter mentioned in his introduction. We are unpacking the vital topic of access to information within community schemes. And essentially what I want to do in this webinar is clarify who is entitled to what when it comes to information. Specifically, we're going to focus on bodies corporate, but we'll also briefly touch on access to information in homeowners associations. So the webinar is coming at a great time, as I said, because as I'm sure you all know, there's a lot of confusion in the industry right now about who is entitled to access information in community schemes and how they need to go about accessing it. And honestly, it's not surprising because we have multiple laws. We have the Sectional Title Schemes Management Act. We have the Promotion of Access to Information Act. We have the Protection of Personal Information Act. We have the Constitution of the Republic of South Africa. We've got case law. And then, of course, we have the recent consolidated set of practice directives, which have been published by the CSOS in July 2025. And not all of these align and say the same thing. So it's really confusing for everyone. And actually, when Peter and Corinne approached me about doing this webinar, I thought, oh my goodness, this is so intimidating because now I've got to figure this whole thing out because it's a deep dive into all these different pieces of legislation, case law, and the practice directive. And we need to figure out how they all work together and what that actually means for us as an industry. So I understand the frustration that people are experiencing. You know, a lot of people in community schemes getting refused access to information that they feel they are entitled to, and they are being asked to jump through what I will feel are unnecessary hoops to get the information that they are entitled to. So let's look at the big picture, the legal framework, and see the complex web of legislation and other laws that are actually relevant to this topic of access to information, specifically in sectional title. So we start with the Sectional Title Schemes Management Act, and this piece of legislation creates a legal relationship between the owners in a sectional title scheme and the scheme's body corporate. And that body corporate is required to collect and keep a host of personal and other information. The Sectional Title Schemes Management Act and its prescribed management rules also give sectional owners statutory rights to access body corporate records, and I will list those specifically in a minute. After the Sectional Title Schemes Management Act, we have the Constitution of the Republic of South Africa. And the Constitution gives everyone the right to privacy, which includes the right not to have the privacy of their communication infringed. And of course, the POPIA Act was enacted to give effect to that specific constitutional right by protecting personal information. By contrast, the Constitution also gives everyone the right to access information, which is held by another and that is required to exercise or protect rights. And so we have PAIA that was enacted, the Promotion of Access to Information Act, to give effect to that particular constitutional right to access information. Okay, so we've got these two conflicting sort of rights in the Constitution, the right to privacy and also the right to access information. Then we have the Montrose Mews case, which is legal precedent clarifying that PAIA does not apply to owner requests for body corporate information, which you are entitled to under the Sectional Title Schemes Management Act and its regulations, including the prescribed management rules. And I'll unpack this for you in detail shortly. And then finally, we have Chapter 5 of the consolidated set of CSOS practice directives, which requires owners to make almost all applications for information to the body corporate through PAIA, which directly contradicts the legal precedent set by the Montrose Mews case. So as you can see, we have a fairly tangled legal framework around this topic. Sectional owners have statutory rights to access certain information from the body corporate. The Constitution gives owners the right to privacy, and the POPIA Act protects that personal information. But the Constitution also gives everyone the right to access information necessary to protect or exercise their rights, and that's facilitated by PAIA. And then we have case law that clarifies that owners don't need to complete PAIA forms for the information that they are entitled to under the STSM Act and the PMRs. And then we have the CSOS Practice Directive telling us that most requests to access information must be made under PAIA. So where do we go from here? And that's this hierarchy of law that you've got in front of you. Okay, so now that we've understand that there are many different laws and guidelines that overlap and sometimes contradict, we need to step back and understand which rules carry the most weight. What do we actually need to apply in the situation? Because this is really important. There are direct conflicts between a number of these elements. So starting at the top, we have the Constitution of South Africa. It's the foundation of all other laws. It's our supreme law. It gives everyone fundamental rights, like the right to privacy and the right to access information. And any law, rule, or guideline that conflicts with the Constitution is invalid, okay? Underneath that, second in line, we have Acts of Parliament, otherwise known as statutes. So these are our national statutes that are passed by Parliament and signed into law by the President. And for our topic today, the key statutes are the STSM Act, the POPIA Act, and PAIA. These acts are binding and directly regulate the rights and duties of owners, bodies corporate, and managing agents. All right, so underneath the statutes, we have regulations made under those statutes. So statutes often empower the minister to create detailed rules, which are known as regulations. And for example, the STSM Act has regulations, which include Annexures 1 and 2, being the prescribed management rules and prescribed conduct rules. These regulations have the same legal force as the statute itself, but they sit below the Act in terms of hierarchy of law. So if a regulation contradicts a provision of the Act, then the Act prevails. And then beneath that, we have legal precedent. So below acts and regulations, we have case law. And this comes from judgments made by our courts. And the Montrose Mews case is a good example here, because in that judgment, the court held that PAIA does not apply to requests for information that owners are already statutorily entitled to under the STSM Act and PMRs. So this ruling is binding on all bodies corporate and lower tribunals like the CSOS, unless it's overturned by a higher court. And then finally, at the bottom, we have the CSOS practice directives. These are essentially internal policy documents that guide CSOS staff and the public. They are persuasive, but they're not binding law. So if they conflict with the Constitution or an act or a regulation to an act or a court judgment, the higher law prevails. And this is exactly the problem that we have with Chapter 5 of the Consolidated Practice Directives made by the CSOS, which requires most access to information requests by owners in sectional title schemes to be made under PAIA. It also requires consent to be obtained in instances where the STSM Act and PMRs don't actually require consent. But because of the hierarchy of law that I've just explained, the CSOS practice directives, when they contradict higher laws, those higher laws prevail. Okay, so even if we look at the CSOS practice directive itself, in its introduction, it says, no interpretation of this practice directive should have the effect of creating a conflict with the provisions of the CSOS Act, the Sectional Title Schemes Management Act, and other legislation and regulations. So that in itself is telling us that the CSOS knows that if there are higher laws in the hierarchy of law that their practice directives conflict with, we need to take precedence for those higher laws. Okay. And the good news is that the CSOS practice directives can be amended relatively easily. So hopefully once the CSOS becomes aware of some of these conflicts, they will be able to amend their practice directives to bring them in line with the higher laws. Okay, if we can move to, yes, structure. Thank you, Peter. Okay, so in terms of what we're going to do in this webinar, I'm going to start by explaining exactly who is entitled to what under the STSM Act and its PMRs, despite the conflicting CSOS guidance in some cases. And then we're going to look at requests for information not included in the STSM Act and PMRs from owners and non-owners. Then we'll move on to how the request must be made. And this is a big thing. When must a PAIA form be used and when is it not necessary to use a PAIA form? Then we'll move on to POPIA compliance. So we're going to look at this from two perspectives. POPIA compliance when considering a request, and also POPIA compliance when disclosure is made. So I'm going to break that up into two different sections. And then we'll look at access to information in homeowners associations, specifically nonprofit company HOAs and also common law association HOAs. And finally, we'll explain the relief that's available to a person when disclosure is unfairly refused. Okay, so if we can go on to the next slide, please, Peter. Thank you. So let's look at the STSM Act itself. Let's look at the statutory rights that people have under not only the STSM Act, but also the prescribed management rules. This is a statute. If we look at that hierarchy of legislation, it's quite high up there, and it gives certain people certain rights to access information. Okay, so Section 3(1)(n) of the STSM Act says that a body corporate must comply with any reasonable request for the names and addresses of the persons who are the trustees of the body corporate or who are the members, which are the owners in the body corporate. Now, this section is very broad. It uses the phrase any reasonable request, and it doesn't place any restrictions on who may or may not make that request. So this means that any person, including a non-owner, is entitled to request the names and addresses of the trustees and owners in the scheme. That doesn't mean that every person who requests these details is entitled to have those details disclosed to them. The test here is it a reasonable request? So the body corporate is only obliged to disclose this information if the request is reasonable. And what is reasonable depends on the purpose for which the information is sought. And we will discuss that in a bit more detail in a minute. But in the meantime, I just want to give you a few examples to give you an idea of the sorts of requests that would be considered reasonable and unreasonable under Section 3(1)(n) for the names and addresses of owners and trustees in a sectional title scheme. So a reasonable request could be made by a bondholder or conveyancer who needs the contact details of the trustees because there's an issue regarding a pending sale or transfer of a unit. Maybe there's a contractor requesting trustee details to clarify the scope of their work, or maybe they need access arrangements. There could be a municipal official needing details for legal compliance or health and safety matters. Or there could be a non-owner who's a neighbor who's trying to resolve a boundary dispute that requires contacting the trustees. These are examples of reasonable requests where an outsider may be entitled to the names and addresses of trustees, for example, and they would have a statutory right to obtain that information. Examples of unreasonable requests. Let's say a marketing company comes to the body corporate and wants all the owners' addresses to send unsolicited promotions. That is not a reasonable request. A private individual asking for a list out of curiosity with no clear purpose, also unreasonable. And as we've all probably seen in practice, a disgruntled former owner who's seeking information to harass trustees or owners, also unreasonable request. And I want to point out a conflict between Section 3(1)(n) of the STSM Act and also the CSOS Practice Directive, because in Chapter 5 of the Practice Directive, Clause 16.3 states that a request made for the owner's names and addresses under Section 3(1)(n) must only be allowed upon consent of the Board of Trustees or members. So Section 3(1)(n) of the STSM Act doesn't specifically require trustee or member consent. It merely requires that the request be reasonable. And as I've explained in terms of the hierarchy of laws, because the CSOS Practice Directive sits below the STSM Act, which is the statute, we follow the statute rather than the practice directives. And this means that trustee or owner consent isn't strictly required to disclose trustee or owner names and addresses, but in practice, it's likely that such a request would need to be approved or rejected via trustee resolution. But there's certainly no requirement for owner consent in this case. Okay, moving on to the next one, please, Peter. We have Section 31S of the STSM Act. And this says if a body corporate receives a written request from an owner or a registered bondholder of a section or their authorized representative, the body corporate must give that person the body corporate's insurance policy and the receipt for the last premium paid by the body corporate in respect of that policy. So essentially, owners and bondholders in sectional title schemes or their authorized representative are legally entitled to access the body corporate's full insurance policy document and the receipt for the last premium paid as proof that the body corporate is actually up to date with its insurance payments. There's no barriers or restrictions here as there are in Section 31N, where the request must be reasonable. In this case, if an owner or a registered bondholder or the authorized representative sends a written request, the body corporate is obliged to give them a copy of its insurance policy and a receipt from the last premium paid. And that's it. It's just a written request and they're entitled to it. Okay. Now, if we move on to the prescribed management rules, we have a whole host of financial information that the body corporate is required to keep. And that's set out in Prescribed Management Rule 26. So what this rule allows is owners, registered bondholders, and the scheme's managing agent. They are all allowed to inspect and copy these documents on application. Okay, and on application does not mean on application via PAIA, as that was actually clarified in the Montrose News case. This just means on application, written request, email request, an informal sort of application. So the financial records and documents that a body corporate is required to keep under Prescribed Management Rule 26, which owners, registered bondholders, and the managing agent are entitled to include proper books of account. And these books of account, this is all fleshed out in PMR 26 if you want to go into it in detail. But basically, these books of account must record all the body corporate's financial activity. They must disclose all amounts recovered from owners. They must include individual accounts for each owner, showing what each owner owes and has paid, and that contain all other information necessary for owners to assess the body corporate's overall financial situation and understand their own financial situation in relation to the body corporate. They must also keep separate books of account and separate bank accounts for the administrative and reserve funds. The body corporate also needs to keep annual financial statements, which have an incredible amount of detail in them. The amounts owed to the body corporate needs to show arrears classified by owners, amounts owed by the body corporate to its creditors, amounts advanced to the body corporate like loans or levy finance, reserve fund amounts and various details related to the reserve fund, insurance policy details, amounts due to the CSAS, etc. It also needs to keep its maintenance, repair, and replacement plan and budgets for the next financial year and the annual trustee report. So we've got a lot of financial information that is required to be kept by the body corporate, and we have owners and the registered bondholders and the managing agent, which are entitled to inspect these and copy these on application. Then moving on to Prescribed Management Rule 27. This has got a lot of documentation in it, and I won't go through everything in detail, but basically this rule requires the body corporate to keep additional governance documents and records, which owners, registered bondholders, and their authorized or their authorized representatives are entitled to inspect. And they're also entitled to be given copies of these documents on written request. Okay, and these documents include things like minutes of general and trustee meetings, lists of trustees, owners, and tenants. This is a massively controversial one because it requires the following details to be kept: full names, ID numbers, passport numbers for non-South African citizens, section addresses, mailing addresses, phone numbers, and email addresses. So a lot of sort of personal information that people want to protect. There's also a whole bunch of other stuff related to the scheme, lists of sections, exclusive use areas, registered bondholders, details of future development right holders, the sectional plan, the legislation, resolutions dealing with changes to common property, consents and approvals given by the body corporate, waivers and consents given by owners, written contracts to which the body corporate is a party, any sort of legal decisions from either an adjudicator, arbitrator, magistrate, judge that involve the body corporate as a party, legal opinions that the body corporate has obtained, and then there's budgets, financial statements, income tax returns, insurance policies, and also correspondence sent or received by the body corporate and trustees. So there's a hell of a lot of information there in PMR 27 that the body corporate is required by law to keep. And we have PMR 27.4, which says that these owners or registered bondholders or the authorized representatives are entitled to inspect and give and be given copies on request. Okay, in terms of timeframes for requests under 27, on receiving a written request for any of these documents from an owner, a registered bondholder, or the authorized representative, the body corporate must comply with the request and grant access to the information or provide copies within 10 days of the written request being received for anything other than the body corporate rules. If it's a request for the rules, then it's 5 days. In terms of fees that can be charged, the body corporate can't charge a person to inspect a copy of the rules or receive a copy of the rules. But any other document under PMR 27, the body corporate can charge a reasonable fee, which is the cost associated with making the copy. Okay, so I'll just have a quick sip of water. Sorry, this is I'm going at lightning speed because I know we only have half an hour and there's so much to get through. Okay, so you can move on to the next slide, please, Peter. So the previous slides where we looked at section 31N, section 31S, PMR 26, PMR 27, all of those list the body corporate documents and records that particular people have statutory rights to access under the STSM Act and the PMRs. And the sections of the STSM Act that we've listed and the PMRs create an existing right on the part of the person who's either the owner, registered bondholder, maybe the managing agent, maybe the owner or bondholder's authorized representative. These people have a statutory right to access the information that they are entitled to access under the Act. And that gives the body corporate a corresponding obligation to provide that person with access to that information. But what about when an owner requests information held by the body corporate that they don't have a statutory right to access under the STM Act or the PMRs? For example, an owner comes and asks for access to CCTV footage, for example. That's not included in any of those provisions that we've listed. In these cases, the owner still has a pre-existing relationship with the body corporate, but they don't have a pre-existing automatic statutory right to access that information that they want, because the STSM Act and the PMRs don't provide for that. So this is where PAIA can fill the gap for owners. And under section 51 of PAIA, the owner will need to show that the record is required to exercise or protect a right, which they will do by completing and submitting a PAIA Form 2 to the body corporate. The body corporate then considers the request based on the POPIA Act, which we'll get into in a minute, and then decides whether to disclose the information or not. And if they do decide to disclose the information, they will need to decide how much to disclose. Okay, and don't worry, I'm going to give you like a little summary overview of all this in a minute. I know it's super complicated and in-depth, so if you're feeling a little bit lost, please stay with me. Hang on, I'm going to get to a much more sort of easy way to understand this in a few moments. Okay, so now we're moving on to non-owner requests for body corporate information. So someone outside the scheme that doesn't own a unit in the scheme. If a non-owner has an existing statutory right to access the requested information under the STSM Act, for example, a registered bondholder requesting the names and addresses of trustees under section 31N, or the scheme's managing agent requesting a financial record under PMR 26.2, then they can make that request directly to the body corporate without going the PAIA route, okay? However, if a non-owner doesn't have an existing statutory right to access the body corporate information requested, then the PAIA route needs to be followed. So let's summarize how requests work for body corporate information for owners and non-owners. And before I do that, I just want to read you an extract from the Montrose Muse case. So if we can just go on to the next slide, please, Peter, I think. So basically, what the judge in the Montrose Muse case said is that PAIA does not apply to Ms. Makaka's, and this is the owner in the case. It doesn't apply to her request to see the bank statements that she demands because it was never intended to apply in situations where a duty to disclose information arises from a pre-existing legal relationship between a person seeking information and the person holding that information. PAIA is rather intended to apply where a person seeking information from a private body would otherwise have no right to it. To hold otherwise would lead to absurd results, mostly by imposing an additional burden on the exercise of existing rights of access to information. And I think that's what many of you have been experiencing after the CSOS practice directives have said that, most access to information requests must be made via PAIA. It's like, why do I need to fill in a PAIA form to get the minutes of a meeting when PMR 27 says that I can just, make a written request? Why do I have to jump through this extra hoop? And that's exactly what the judge in the Montrose Muse case was saying. So, to summarize, let's look at owner requests first, okay? For information that an owner is automatically entitled to access under the STSM Act or the PMRs, no PAIA form is required, okay? Despite the fact that the CSOS practice directive in Chapter 5 says that it is, it's not, because that conflicts with higher law, which directly and very specifically clarifies that PAIA does not apply to a situation where a person has a pre-existing legal relationship with the body that they are requesting access to information from and which they are entitled to. Okay, so if it's something in 31N, 31S, 26 or 27, no PAIA form required on the part of an owner. For information that owners are not automatically entitled to access under the STSM Act or the PMRs, so this is where, for example, that CCTV footage example, the body corporate may require them to access via PAIA because they have no automatic statutory right to access that information. But because owners have a pre-existing relationship with the body corporate, the trustees can use their discretion and allow certain requests without PAIA forms being filled in. So, for example, if the trustees believe that disclosure is not controversial, or if the information request is fairly inconsequential, then they don't need to make that owner jump through multiple hoops, including PAIA, to get the information, because there is a pre-existing legal relationship there. So PAIA may or may not apply in the case where the owner doesn't have a statutory right, but that's really at the discretion of the trustees. Okay, we're going back to the CSOS practice directive. It has a few clauses which mention when owners don't need to use PAIA. One of them is when they request generic information that doesn't contain the personal information of an identifiable person. And they say that this can be requested via email or without completing the PAIA form too. So that's great. Then we also have another clause, which is 1618 of the practice directive, and it says that parties involved in dispute resolution proceedings are entitled to access information and documents insofar as those relate to the dispute. And in these cases, the parties don't need to follow POPIA or PAIA to access the information. So to give the CSOS practice directives they do have some areas where they say we don't need to go through PAIA. So that's in terms of owners, okay? Owner requests for information from a body corporate. What about non-owner requests? For information that a non-owner is automatically entitled to under the STSM Act or the PMRs, again, no form is required because there is a statutory right to access that information under the STSM Act and the PMRs, okay? So that's, for example, a bondholder. It's not an owner, but the legislation contemplates that that bondholder can have access to that particular insurance policy, for example. They don't need to go through PAIA. For information that they are not entitled or automatically entitled to access under the STSM Act or PMRs, the body corporate must require them to access via PAIA. There's no discretion in this case because there is no pre-existing legal relationship between that outsider and the body corporate, okay? So the discretion comes in with PAIA if it's an owner who has an existing legal relationship with the body corporate and they're asking for something outside the scope of the STSM Act and the PMRs. That's when the discretion can come in. Do we want to ask this owner to use PAIA or not? Okay. Now let's look at PAIA compliance. All bodies corporates are considered private bodies under PAIA, and they must have an appointed information officer, which is usually one of the trustees or the scheme's managing agent, and they must also have a PAIA manual. If the request for information is being made via PAIA, then the requester must complete Form 2 and submit that to the scheme's appointed information officer. The requester must also pay a prescribed fee, which is currently 140 Rand, I believe, plus potentially some additional charges for copying, if relevant. Unless the person is requesting their own personal information, in which case no fee is payable. They're exempted from the fee. Okay, so let's talk about POPIA compliance when considering the request for information. Firstly, we need to verify the identity of the requester. We need to make sure that the person who is asking for access to the information is who they say they are, or that they have the authority to act on behalf of the person making the request. So if somebody is making a request to access information on behalf of somebody else, and they claim to have authority to act on that person's behalf, the first thing that the trustees need to do is get written proof of that authority. So is there a power of attorney in place? Is there a company resolution in place, etc., which actually allows that person to access that information on behalf of the person entitled to it? Secondly, they need to confirm the purpose of the request. What does the person need this information for? And it has to be for a legitimate purpose. And as we know, or I'm sure most of you know, a legitimate purpose is genuinely related to the governance, management, or administration of the sectional title scheme. Okay, so for owners exercising statutory rights to access information, they've already got those rights to access the information under the STSMA, okay? They are entitled to it, but this question of purpose really informs how much information the trustees are required to disclose, because disclose versus redact, I should say. And redact is when you sort of cross out or, blur information that the person doesn't need to see to meet the purpose of their request. So we'll deal with that shortly when we get to the minimality principle under POPI. But essentially, it's always important, regardless of who's requesting the information, to find out what's the purpose? What do you want to do with this information? Now, for persons with no statutory right to access the information under the STSMA, the purpose will inform whether or not to move on to the next step or to simply reject the request outright. The next step is necessity, okay? So if the request is being made by someone with no statutory right to access the information, you need to ask, is the disclosure of this information genuinely necessary to achieve the legitimate purpose that this person is trying to achieve? If it is, then the request should be approved, subject to the principle of minimality, and no consent is required. And don't worry, I'm going to also flesh this out for you in a second. But if not, the request should be denied unless consent is obtained from the relevant data subjects to voluntarily disclose their personal information. So essentially, if the person has been verified, the person has a statutory right to access the information, and the purpose of the request is legitimate, and disclosure is necessary to achieve that purpose, then we move on to the next step of POPIA compliance. If the person isn't verified, we don't know who they are, or they don't have the requisite authority, they don't have a statutory right to access the information, the purpose for accessing the information isn't legitimate, or the disclosure isn't necessary to achieve that purpose, then the request should be denied unless consent is obtained from the data subjects to voluntarily disclose their personal information. Now we can go into the next one. Thanks, Peter. So let's look at PAIA compliance at the when disclosing information, okay? So prior to disclosure, the trustees and or the managing agent need to consider the information contained in the document or record that's being requested and ensure PAIA compliance by implementing what's called the principle of minimality. And this essentially means that you need to ask yourself, what is the least amount of personal information needed to achieve the stated purpose? So any information that is contained in the document or record that's being requested, for example, ID numbers, phone numbers, those sorts of things, if those details are not required for the person to achieve their stated purpose or exercise or protect their rights, then that additional information needs to be redacted, crossed out, blurred out, not visible prior to the disclosure. And once they've done that, they've sort of implemented this principle of minimality, they've redacted what's not necessary. The trustees then provide access to the document or record while simultaneously imposing a strict use limitation disclaimer. So for example, a disclaimer could say, this information is provided solely for the stated purpose and may not be used for any other purpose, distributed or stored longer than necessary without a separate lawful basis or consent. Okay, so the body corporate is covering itself by saying, we are giving you this information because it is within your rights to receive it, but you may not use it for any other purpose than what you've told us you're using it for, which falls into our legitimate purpose and allows us to disclose. I just want to mention here a note on consent and the CSOS practice directives, because we know that if a person has a statutory right to access information, for example, an owner requesting owner list under Prescribed Management Rule 272B, and the legitimate purpose necessitates the sharing of owner contact details, under POPI, no consent is required prior to disclosure. I know many managing agents and trustees are using POPI as a shield to say, if you want any contact details of other owners, you have to get consent from everyone before we can share that. And that's not the case if there is a legitimate purpose that necessitates the sharing of that information under the POPI Act. Okay, so let's look at an example. For example, we have an owner who feels that the trustees are mismanaging body corporate funds, and they want to get the trustees off the board, and they also want to bring these issues to light for the other owners. They are entitled to requisition a special general meeting under 27(4). And to do that, they need contact details of the other owners. Okay, so they can come to the trustees and say, we would like, by written request, to receive the contact details of the other owners in the scheme. And in practice, many managing agents are just saying, no, sorry, we've got to get consent from everyone. And that's not the case. This is a legitimate scheme governance management administration purpose. And so under the POPI Act, if it is a legitimate purpose, then there is no consent required before disclosing that information, provided that the principle of minimality is included or considered, and also use limitation disclaimer, I should say. So in that case, you might not want to share all the owners' mobile numbers or cell phone numbers, but maybe you want to just share their email address or the address of their section. And that means that the person does have a way to contact those people without necessarily disclosing too much information that could breach those persons' rights to privacy. So we have the CSOS practice directive saying that, any information required under PMR 27(2)B, these lists of owners and trustees and tenants, this is all considered personal information, and consent must be obtained from the data subject, who's the person, the relevant owner, trustee, or tenant, before their personal information is disclosed. And I disagree with that, because under POPI, consent isn't required if there is a legitimate purpose which necessitates the sharing of that information. So we just need to be careful in terms of, requiring consent when it's not necessarily required. It's great if you can get consent, you're covering your bases, that's awesome, but also it's not required in all cases. So consent is not the only or primary lawful basis to disclose Prescribed Management Rule 27(2) lists. If it's a legitimate scheme governance scenario, it's unnecessary to ask for consent before disclosure, because the disclosure is compatible with the purpose for which the information is being collected. Okay. Also, just one last thing on that slide is that in terms of the CSOS practice directive, sharing personal information with members of the community scheme or debt collectors relating to the defaulters in terms of levy payments or members who have failed to adhere to the community scheme rules will not require members' consent. So basically the CSOS says, most of this information requires consent, but there are these limited sort of situations where consent is not required. Thanks, Peter. We can move on to HOAs now. So as I said, we're going to briefly touch on access to information in HOAs. We have two different types of HOAs in South African law. They can either be constituted as non-profit company HOAs or common law association HOAs. So let's start with non-profit company HOAs. If we can go to the next one, please, Peter. Non-profit company HOAs are governed by the Companies Act and the HOA's Memorandum of Incorporation and any other governance documents that it has made underneath that. So the Companies Act provides that members of a non-profit company, which are the owners in a non-profit company HOA, as well as members of the public, have certain rights to access specific company information. And these are all detailed in Section 26 of the Companies Act. So, for example, under 26(1), owners in a non-profit company HOA have the right to inspect the HOA's MOI, any amendments to it, any rules made by the HOA company, records pertaining to the company's directors, the HOA's reports to annual general meetings and annual financial statements, notices and minutes of all member meetings, copies of all written communications sent to members, and the members' register. So that gives owners statutory rights to access that information because it's contained in the Companies Act. Okay. Then Section 26(2) provides non-owners with some entitlements to access non-profit company HOA information as well. And this includes the members' register and the register of directors. Now, in addition to the information rights that are included in the Companies Act, we also have the MOI of a non-profit company, which can establish additional information rights with respect to any information pertaining to the company. So the information listed in Section 26(1) and 2 of the Companies Act are the basic statutory information rights that are held by owners and non-owners in non-profit company HOAs. But the HOA's MOI might allow for additional access rights. So we have these statutory rights, which owners and non-owners have under the Companies Act. That's a statute. And then we also have potential additional rights to access information held under the MOI, and those are contractual rights that owners have because homeowners associations, memorandum of incorporation or constitutions are considered contracts between the members. Okay, so the non-profit company HOA must facilitate access to information requests by allowing inspection during business hours and providing copies for a nominal fee with access to records to be provided within 14 business days. Okay, so let's go into the next one. Non-profit company HOA must a PAIA form be used. So if a person requesting access to information that they are entitled to, as set out in the previous slide, which means that they're exercising their statutory right to access information as provided for under the Companies Act, or they're exercising their contractual right to access information that they are entitled to under the HOA's MOI, then the request can generally be made by direct request to the HOA, either in person or through an attorney or other personal representative, and this doesn't require a PAIA form. But they may choose to go through PAIA if they want to, okay? But it's not mandatory. If you have a statutory or contractual right as a HOA owner or somebody who's a non-owner connected to an HOA, you can make a direct request to the HOA without using PAIA. But PAIA may be used if you want to, okay? If the request for information is outside the scope of your statutory or contractual rights, either for a non-owner or an owner, then PAIA must be used and an application to the HOA's information officer must be submitted. Okay. Now, moving on to common law HOAs, please, Peter. So, as I'm sure you know, there's no statute or national statute that specifically regulates common law HOAs, and therefore there's no prescribed list of documents or records that owners and non-owners are entitled to access, as they are for non-profit company HOAs. So the Common Law Association HOA's constitution is absolutely key here. The constitution should cover what documents and records owners are entitled to inspect and copy, how they may do so, timeframes, fees, etc. If the constitution is silent, then committee members' fiduciary duties to act in good faith and account to members imply a duty to keep accurate records and adequate records and account to the membership. Now, must PAIA be used when it comes to common law HOAs? Use PAIA whenever the requester seeks records the HOA is not already obliged to disclose under its constitution, or when the requester is a non-owner, then it's most likely that they're going to need to do a PAIA request because there's no contractual right to access the HOA's records under its constitution. Okay, and then in terms of PAIA compliance for both HOAs, non-profit companies, and common law associations, it's exactly the same as what we went through for sectional title schemes. You need to verify the identity of the requester. You need to figure out what the purpose of the request is. What do they want to use this information for? Does it fall within a legitimate purpose within the HOA's management, administration, or governance? Is it necessary to disclose this information to meet that purpose? If it is, then we go to the principle of minimality. What information here is not necessary to meet that purpose? What can we redact? how can we protect the privacy of the persons who have personal information included in this document? And then once it is disclosed, it should be disclosed subject to a use limitation disclaimer. You can only use it for the specific purpose, and you cannot use it for any other purpose without consent or another lawful basis. And then finally, we're moving on to relief. So what if an access to information request is refused? CSOS has a beautiful order under Section 39(7)(a) of the CSOS Act, which allows an adjudicator to issue an order declaring that the applicant has been wrongfully denied access to informational documents and requiring the association to make such informational documents available within a specified time. That can be used by anyone in a body corporate, an HOA, or anyone with material interest in the community scheme. And you should use that when you requested records that you have a statutory entitlement to or a contractual entitlement to, and your request has been refused. That's very clear. Once you can show, okay, under this PMR, I'm entitled to this. The body corporate said no. Maybe they stood behind PAIA or POPI or whatever. You can go to the CSOS and say, actually, I'm entitled to this and I want access to it. You can also use this order even for non-statutory records, which are closely tied to scheme governance. So because, as we know, owners have a pre-existing legal relationship with the body corporate, there's a sort of, iffy line there as to whether PAIA should actually be used or not because of the Montrose Muse case, which says if there's a pre-existing legal relationship, PAIA was not designed for that. It was designed for where there's no right or no relationship between the requester and the person holding the information. Now, if you're dealing with a non-profit company, HOA, the Companies Act has some remedies. There is a section 163 order, which is an oppression or unfair prejudice. A person who is treated oppressively can ask the High Court for wide remedial orders, including compelling disclosure of information. And under the common law, there is interdicts or declaratory relief where the High Court can order specific performance or inspection where statutory right exists and has been denied. In terms of common law HOA remedies, we are looking at enforcing the Constitution. And so that allows the particular person to apply to court for specific performance, which allows them to inspect or copy the records that they're looking to access. Now, when it comes to PAIA, if the request was made under PAIA to access information from a private body, which includes a body corporate or an HOA, and is refused, unfortunately, PAIA doesn't have an internal appeal process. So your remedies in that case are either to go to the CSOS under that wrongfully denied access order, or you can make a PAIA court application to compel access, or you can make a complaint to the information regulator about procedural PAIA violations, which are useful but not always a substitute for a court or CSOS order. So just expanding on the information regulator complaints about PAIA and POPI, who can use it? Anyone, an owner or a non-owner. It can be helpful if the body corporate or the HOA ignored PAIA timelines, mishandled personal information, or relied on POPI incorrectly to block disclosure instead of redacting, for example. And you can file a PAIA complaint for procedural non-compliance or a POPI complaint for unlawful processing, failure to minimize, failure to secure, etc. And what the regulator can do in those cases is request information, issue information, issue informational enforcement notices, require corrective action, or refer matters. So practically, this avenue is a lot slower, and it's best to use in parallel to CSOS or court to pressure proper handling, but it's not on its own necessarily the best route to take. So that is the relief. And then finally, we can move on to the next slide. We can move on to our Q&A. And I just want to say this is such a complicated topic. And I've got these two things here, which I've written out on pieces of paper that it's like a decision tree. Like if who's requesting, is it the owner? Is it a non-owner for body corporate, blah, blah, blah. And you go through the whole thing. And I'm going to make these really pretty and then give them to Trafalgar to share with you guys, because I know what I've said here sounds like a lot of information thrown at you. But if we sort of dial it down to the principles, we can actually set it out in a way that makes a lot of sense and that can help you understand when disclosure is necessary, when it's not, when PAIA is necessary, when it's not, what needs to be redacted, what doesn't, all of that sort of thing. So that is it. Thank you.
Jennifer, thank you so much. It's so difficult bringing sense to so much convoluted and uh, mixed information that you're getting through all of the different pieces of legislation. So thank you very much for setting that out. Corinne has been feverishly typing away on her laptop, answering questions. I'm sure there are a few that have gone unanswered. Corinne, you can unmute yourself and go for it.
Excellent. Thank you so much, Peter. I actually have a question from our MD, Andrew Schaefer, who sends his apologies for not being able to attend today. He's just at a situation where that he doesn't have bandwidth at the moment. So from his side and from my side, we basically get, as managing agent, we get a lot of queries for information. And people insisting on the information because of, as you said, the Act says body owners must have access to the information. But just to explain to them that the managing agent is not the body corporate. The Act says, the Sectional Title Schemes Management Act says the body corporate must supply the information, but we're not the body corporate. The trustees represent the body corporate. So what we were contemplating is if you think it will be possible for a trustee resolution to be set up, that we get our trustees to sign, to say that if an owner asks for this information, and like a tick box, if they ask for the financial statements, if they ask for the budget, if they ask for owner's contact details, like have a tick box, and then the trustees can tick that off and sign the resolution to say, if an owner asks for any of the following information, managing agent, you don't even have to ask us. You can just give it through to the owner because the owner is entitled to that information because of the legislation. So, Jennifer, what do you think of such a resolution?
Yeah, I think it's a brilliant idea because it's going to streamline and, take the admin out of a lot of back and forth with the trustees. It needs to be set up properly, though. So I think it's Prescribed Management Rule 21.3G, which sets out delegations. So basically, as you said, the body corporate has its powers and functions. Those are to be exercised by the trustees under Section 7 of the STSMA. The trustees have the power under Prescribed Management Rule 21.3G to delegate any of their functions and powers, which are any of the body corporate's functions and powers, to anyone, okay, multiple people. And so you need to just ensure that is a written trustee resolution. You need to follow the requirements of 21.3G. Written trustee resolution, it sets out the exact power being delegated. It sets out the scope. It sets out any spending limits. There's a few things that just need to be sort of like, the boxes need to be ticked in terms of make sure that it follows 21.3G. And if that is in place, then absolutely, and that will save a lot of time. Another option is to include that specific delegation in your management contract so that you don't actually have to go and get a separate written resolution from the trustees. It's included as a delegation in the management agreement, and so it's there from the beginning. So for maybe any new schemes, you could do that. For existing schemes, you could go and get a trustee resolution in line with 21.3G.
Excellent. Thanks, Jen. Then another question, the Montrose case that you refer to, does that also apply to homeowners associations?
No, unfortunately, like we can look at some parallels, but it was specifically in relation to sectional title and specifically in relation to, a owner's ability to access financials or bank statements under PMR 26. But there are some principles there that I think would be persuasive for homeowners associations and judgments either by courts or CSOS adjudicators in the future, because what it does say is that PAIA was intended for situations where there's no pre-existing relationship between the person requesting the information and the person holding the information. And we can see that parallel between bodies corporate and HOAs where there is an existing relationship between the owners and the body corporate or the HOA. There's already a pre-existing relationship. So although it's not directly applicable, I think it's persuasively applicable. And I think that any adjudicator of the CSOS or the courts would be, sort of, I don't want to say foolish. I want to say that, it would make sense for them to apply similar principles. For example, if under the Companies Act, a nonprofit company, HOA, is required to give, certain information to a person. Why would you need to go through PAIA? There's already a statutory right there. There's a pre-existing relationship. The principles, I think, are very transferable, although it's not bulletproof because we're talking about different community schemes.
Thanks, Jen. That's all from me. Thanks, Peter.
Thank you very much, Corinne. We've got 2 minutes left. Jen, I actually think you answered everything on my list as well. Thank you so much. That was a wonderfully informative session, and I've seen we've got very similar comments on the Q&A. So I just want to thank you so much for putting everything together the way that you've presented and just providing your members, our members, with all of the information. We truly appreciate it. Thank you.
Absolutely. Thank you, Peter. And I think, we've discussed, and I've actually had a call today with some of our HOA students where they were saying, don't you have a course on POPI? And we spoke about this the other day. And, I was thinking about taking this and trying to flesh it out into a bit of a course or an ebook or something, because it seems like there's just so much miscommunication and misunderstanding in this area. And it's really hard in a 1-hour session to unpack everything. So yeah, I will definitely be working on some sort of other offering that can allow people to really understand this in more detail and in a simplified form.
That would be excellent. Thank you so much, Corinne. Thank you as well. Everybody, the contact details is currently up on the screen. Please contact us should you need to do so. I'm sure there's a bunch of unanswered questions that you can just direct to us as well. We've got 2 more webinars left for the year. Can you believe it? September, October, and then last one in November. And as always, just thank you very much for joining us. The recording is going to be available if you'd like to share that around, as well as the slides. Thank you so much.
Awesome. Thank you, everybody.